Good morning, everyone. Welcome to the 14th study circle session of VP Shintre Associates. Today's topic is environmental protection laws and practice before the NGT. And we have Advocate Aayush Singhvi and Advocate Maitreya Ghorpade with us, who are full-time practitioners in this field and also practice regularly before the NGT. To give a brief background about the study circle session. It was started by Advocate VP Shintre and Advocate Bendre, and these sessions would be conducted in the men's bar room. Thereafter, carrying the baton forward, Advocate Vaishali Bhagwat and Advocate Pramod Bendre would conduct these sessions. And now in this digital age, we have moved to having these sessions over Zoom. We also share the write-ups for these sessions on our study circle webpage, and we also put up these videos, record these videos and put them up on YouTube for those who could not attend our sessions. I would request everyone to kindly switch off their video and turn off their audio. And with that, I would request Shruti Auti to kindly introduce our speakers for today. Thank you.
Thank you, Kunal sir. Good morning, everyone. I am Advocate Shruti Auti. I welcome you all to the 14th study circle session organized by VP Shintre and Associates. So our today's topic is Introduction to Environmental Protection Laws and NGT Practice. So we have two guest speakers for today's session. First is Advocate Aayush Singhvi. Advocate Singhvi is a graduate of the National Law University, Jodhpur, batch of 2011. He has a degree in Business Administration and Law with Business Law Honours. He started his career with Bombay solicitor Mr. Akash Vani, MLS Vani and Associates. He was exposed to various commercial laws and civil disputes and regularly appeared in the courts and the Tribunal of Mumbai. Thereafter, he joined a young startup law firm called RDA Legal, and he was in charge of dispute resolution wing of the Mumbai office. He conducted various litigations, arbitration, civils and criminal trials and appellate issues. During this career lasting 9 years, his pet cause has always been the environment. So he is a certified scuba diver, a trekking enthusiast, and a regular volunteer at various animal shelters. So in pursuance of his lifelong goal of working for public interest environmental issues, he had the honor of joining LIFE, that is Legal Initiative for Forest and Environment. So after joining LIFE, Advocate Singhvi has been privileged to appear before National Green Tribunal related to a variety of environmental issues, including air pollution, water pollution, illegal constructions, illegal polluting industrial projects, etc. Our second speaker is Advocate Maitreya Ghorpade. Advocate Ghorpade is an alumnus of HNLU Raipur, having received an BA LLB with honors in his, constitutional law. He's based out of Pune and he manages the Western Zone matters of LIFE and practices regularly before the Pune bench of NGT. He also runs his own podcast, What on Earth, which deals with environmental issues. So I welcome our both the speakers on behalf of everyone. Thank you.
Thank you, Shruti. So Aayush and Maitreya, before we start, I would also request both of you to, also tell our audience how you got into this field, and also if you could tell us a little bit about your organization LIFE. With that, I hand over.
Would you like to take that, please?
Sure. So to first of all, thank you, VP Shintre Associates, for inviting us over. It's not often that people are interested in talking about environmental law and learning about it. So thank you so much for the opportunity, and to all the participants, I welcome you. And I hope Aayush and I can provide you with some insight into what it's like being an environmental lawyer in India in 2021. So how did I get into it is, I mean, it's a very long story and we only have the session for about an hour and a half. So long story short, my family has sort of the philosophy with which I've with which I've been brought up has always valued nature to a very high extent. My father's a farmer and my mother's a lawyer. So in some ways, a lot of people say I'm a bit of like an amalgamation of them both. I'm doing environmental law. basically through my process in law school, I realized what a powerful tool a law degree really is. And I feel that utilizing it for any other purpose just seems like, a waste, that I'm sort of cheapening the value of this degree. So through law school, I figured that this is something that I wanted to do. And given the climate change crisis that we face right now, I feel it's something that is of utmost importance. Um, what working at life is like is just unbelievably fascinating. The fact that our seniors are who they are, first and foremost, such experienced, such driven advocates, and who have been pushing the cause for environment for, decades now, much before it became like a hot button political socio-cultural issue, So I have the deepest respect for such people. And just if you look at their CV, it speaks for itself. It's a very illustrious, and they're very young. So the fact that I get to interact with people like that is fascinating. And the kinds of cases that I have been entrusted with, dealing with all kinds of government projects, mining companies, forest matters, wetland cases, all the whole range of them is it really has exposed me to quite a wide variety of people as well as problems at a very young age. So I'm very thankful for that. Rest, I'm sure Ayush can fill you in. So thank you so much.
Thanks a lot, Maitreya, and thanks a lot for the introduction, Shruti and Kunal. Shruti already gave you most of my motivations, which is again a basic love for nature. You have to have a love for nature and the people. It's not just nature, but the people who live in nature, who are like to understand that we are all part of this ecosystem. With this understanding, I have always wanted to move ahead and do something substantial. It took me a long time to figure out what to do about it. I used to do a lot of pro bono cases. I used to do a lot of volunteer work while pursuing commercial law. But as time has passed and I've gained experience, I have realized that unless you're doing advocacy for what you believe in, you're not going to be a good advocate, in my opinion. So I immediately started looking for opportunities where such work could be done. And I was surprised to find that there are actually a lot of people in the field who are very hardworking, who are very driven. And the top most of them is Life, Mr. Ritvik Datta, Mr. Rahul Chaudhary. The founders and trustees of Life are eminent lawyers who inspire everybody, all of us working with them, and the large world around as well. They have won many accolades. One of the greatest things about Life is that it does not focus on one or two issues. Most organizations, they will take either a marine environment or forest or tribal development. They will pick one issue and then they will put all their attention into it. Life puts all their attention in every aspect of the environment, every environmental law, every new policy that is coming out, be it forest, be it any ecosystem, the different kinds of ecosystems that we have, the different biomes that we have. They are looking to improve all of them and try to bring environmental justice and democracy to this country, which is another essential aspect of environmentalism, which is that there should be people participation, there should be understanding among the populace of what the issues are and how to deal with them. So in this regard, our presentation primarily today is going to be on environmental laws and the National Green Tribunal functioning. I'll start with an introduction to the laws on what environmental law is in India, what its genesis has been, and what are the basic laws that we generally deal with. After which I'll hand over the floor to Maitreya, who will take you through the practice of the National Green Tribunal, various important cases that we have worked on and that he's come across. So
Ayush, just before you start, considering that the idea of this session is to give a practical idea about how environmental laws or NGT would work. Could you just let us know, as to what, if I'm a lawyer, what sort of clients would I have? What sort of matters would I take before the NGT? Before you come to the main content, like how does this exactly work? When you're an environmental lawyer, what sort of, like I said, what sort of clients would someone someone would approach me for a civil case? Would someone similarly approach me for an environmental matter, or is there like a separate set of persons who are into this practice, something like this?
From my experience, there are multiple ways in which you approach the NGT. Again, Maitreya will elaborate upon that because that is part of our presentation. But to give you a brief idea, anybody can be a litigant in an environmental matter. If there is garbage being dumped in an area near you, then you can go to the NGT. You do not need to be an advocate to approach the NGT either. Anybody can approach the NGT. As an advocate, part of your responsibility is also communication of environmental laws. So you work with other organizations who are working in the environmental field, etc. You go meet people who face problems due to various environmental issues, encroachments, etc. And then you assist them in bringing the matter to the National Green Tribunal. It's a very different practice from your traditional commercial practice. If most people are commercial or criminal practices, most people are aware of that, which is where you mostly go to court and you sit in your chambers and people will come to you through word of mouth. In my experience, this is slightly different. You have to take one step ahead. You have to work a little harder. You have to go ahead, gather material yourself. You have to go interact with people. You have to go to the sites and visit the areas to see what encroachments are going on. So it requires a lot more investment on your personal part.
Right.
And a lot more interaction with the community around you. Maitreya, would you like to add to that?
Yeah, just one small point. I definitely agree with what you've said. Except I feel the need to draw a distinction. This is the kind of work that life is undertaking because we only sort of work with people trying to safeguard environmental rights, trying to protect the environment. Which is why our profile of work is slightly different from what other environmental lawyers might do, because a lot of environmental lawyers, in fact, in my opinion, every single environmental lawyer except for life will take matters where sometimes they defend the government, sometimes they will defend some private corporation, you know, or sometimes they will file a case on behalf of some kind of company, industrial complex, so on and so forth, who are trying to basically protect their own commercial interests. But environmental laws have come in the way of that. So to circumvent that, to bypass that, to sort of get past it, they will hire an environmental lawyer. But this is different from the kind of work that we do. Now, the kind of work that we do necessarily requires, as Aayush has put it so eloquently, a very thorough, very rigorous on-the-ground experience, where fact-finding, where going and meeting individual clients, where taking up their cause voluntarily, all of these things are part of it. And a huge portion of our clientele are individual people affected by projects, or there will be some kind of NGO or some civil society organization. So these are usually the kinds of people who approach us because they are typically affected by some governmental project, by some private initiative, you know, by some ill-conceived development plan. So that is essentially how the distinction, I feel, is there in our work and other environmental law.
Right. Yeah. So okay, thank you for that. And Aayush, you can take the session.
Sure. So let me start with the genesis of environmental law in India. Now, as we are all aware, India is an ancient country. We've had civilizations for thousands and thousands of years. And to be honest, we've had this discussion on what environment is, how environment should be treated, and what human interaction with environment should be, has been a topic of conversation throughout that time. In ancient India, we had Harappa and Mohenjo-daro civilizations. And as we know, they were very well aware of sanitation, hygiene. They had well-developed sanitation systems, canals for irrigation, underground drains that were covered. So this is also environmental law, where sanitation, hygiene, irrigation, all these aspects come into it. We had great authors and readers such as Charak, who wrote the Charak Samhita, where he spoke of water cleanliness and purity. So even in those times, people were aware that clean water is essential for life. We had Arthashastra, where Chanakya spoke about forest conservation, management, wildlife protection, control over hunting, where it was understood by those people as well in that time as well that uncontrolled hunting or uncontrolled deforestation is going to lead to poor effects in poor life conditions in general. After that, we came to a bit of a hiccup when the medieval India started, roughly 1638 AD to 1800 AD, where there was a lack of significant environmental jurisprudence. Certainly, some restrictions were placed on hunting and cutting trees, etc., but these were more for economic exploitation or hunting for pleasure by royals. During this time, we saw a lack of environmental justice and, well, even though it was not a known concept at the time, environmental democracy. So this period also saw, from what we understand, a significant decrease in the forest cover in India. After this, we enter the British colonial period, roughly 1800 to 1947. Now, the Britishers, they came from an industrial time. Industrial revolution was just beginning. So slowly they had started to understand that, yeah, there were certain things that were required, that rampant hunting or rampant deforestation would have deleterious effects. It did not take away from the fact that they came to India for economic exploitation. They wanted to exploit the natural resources of India, but they began the genesis of what we currently know as modern environmental law and modern environmental statutes. We saw the original Shore Nuisance Bombay and Colaba Act 1853, which had imposed restrictions on the fouling of seawater. We saw the Merchant Shipping Act of 1858, which dealt with the prevention of sea pollution by oil. We saw the Bengal Smoke and Nuisance Act of 1905, the Bombay Smoke Nuisance Act of 1912, both of which were regarding air pollution, which was going on there. They were aware that rampant hunting was leading to a significant decrease in biodiversity, and they came up with the Wild Birds and Animal Protection Act 1912, which put restrictions on hunting where permissions were required. They started the first Indian Forest Act in 1927, where they brought forests under common government. Again, this was mostly for exploitation purposes. They wanted timber, so they wanted control over forests. There were significant environmental injustices done during that time, which affected the dwellers, the forest dwellers, tribals, etc., who used to live in those areas. Let's come to independent India now and what the situation is currently. Many people speak of how our constitution had a lot of foresight and imposed a duty upon all citizens to protect the environment. But it was not so at the very beginning. Article 51A, which says that it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have a compassion for living creatures. Or Article 48A, which was enacted to put a duty upon the state as well to protect and improve the environment of the country and to safeguard the forests and wildlife of the country. Now, these came after the 42nd Amendment in 1976. And later on the 86th Amendment in 2002 as well. But it was during the 42nd Amendment in 1976 that we first saw environmental jurisprudence truly coming up. Another important aspect of this was that in this amendment, the forests and protection of animals, wild animals and birds was transferred from the state list to the concurrent list, allowing the central government to make necessary legislation dealing with the issues on the national level. Prior to this, we used to have like the Bihar hunting rules, the Bihar Fishing Act, the Bengal Fishing Act, etc., which were all done away with once the central law started to come into place. Again, the driver for this was the Stockholm Declaration of 1972. Under Prime Minister Indira Gandhi, the country began its first foray into environmental law, protection, conservation, and justice. In 1972, she set up the National Council for Environmental Policy and Planning, which later evolved into the Ministry of Environment and Forests, and which is now the Ministry of Environment, Forest, and Climate Change. Having an idea of what the history is of this of environmental laws in India, let's move into some specific laws. One of the first laws in this was the Wildlife Protection Act. The Wildlife Protection Act 1972 was aimed at more of a rational and modern form of wildlife management. I'll take you through some of the provisions of this act and through the statutory authorities that are created under this act. Now, the authorities under this act primarily, the central government created the Director of Wildlife Preservation, along with assistant directors and other officers subordinate to the director. And the state governments were given the power to appoint chief wildlife wardens who head the wildlife wing of the departments and exercise complete administrative control over protected areas within the state. These protected areas were again, for the first time, defined within the Wildlife Protection Act. Besides this, the state governments also appoint wildlife wardens in each district. To come to some salient features of the act, there is a prohibition of hunting of any wild animals specified in schedules 1, 2, 3, and 4 of the act. These schedules are basically on the basis of how endangered they are. They often refer to IUCN guidelines as well. Now, it's good to remember that when this act first came out, hunting wasn't completely prohibited. It was merely regulated. But with time and with further amendments, hunting of wild animals is completely prohibited in India. An exception to this is that a wild animal listed under these schedules can be hunted or killed only after getting permission of the chief wildlife warden of the state if, one, it becomes dangerous to human life or to property, including standing crops on any land, or two, it is disabled or suffering from a disease that is beyond recovery. Besides this, the Wildlife Protection Act also puts a complete prohibition of cutting, uprooting specified plants. It prohibits uprooting, damage, collection, possession, or selling of any specified plant from any forest land or any protected area. Again, there is an exception that the chief wildlife warden, who is appointed by the state, has the authority to give permission for uprooting or collecting a specific plant for the purpose of education, scientific research, preservation in a herbarium, or if a person or institution is approved to do so by the central government. Besides this, the Wildlife Protection Act laid down wildlife sanctuaries and national parks, whereby the central government has the power to constitute any area as a sanctuary, provided the area is of adequate ecological, faunal, floral, geomorphological, natural, or zoological significance. The government can also declare any area, including any area within the sanctuary, as a national park. They can appoint collectors to administer the area declared as sanctuaries. Other than this, this act also created various other bodies. We talk about which work at national and state levels to implement the act. We have the National Board of Wildlife, the State Board of Wildlife, Central Zoo Authority, and National Tiger Conservation Authority. Let's go into a little bit of detail into what these authorities are, because that is essential to understand how the system functions. The National Board of Wildlife is constituted by the central government. It is the apex body for the review of all wildlife related matters and for the approval of projects in and around national parks and sanctuaries. This is chaired by the Prime Minister and is responsible for promotion of conservation and development of wildlife and forests. Generally, the Minister of Environment, Forests and Climate Change is the vice chairperson of the board. It's an ex officio position. It is important to note that this board is advisory in nature and can only advise the government on policy making for conservation of wildlife. It does not have specific enforcement authorities. The National Board of Wildlife also has a standing committee. It constitutes a standing committee for the purpose of approving all projects falling within the protected wildlife areas or within 10 kilometers of any protected wildlife area. Again, this standing committee is chaired by the Minister of Environment, Forest and Climate Change. Moving on from the National Board of Wildlife, the Act also creates state boards of wildlife, where the state governments are responsible for constitution of these boards. Generally, the chief minister of the state or the union territory is the chairperson of the board. The board advises the state government in selection and management of areas to be declared as protected areas. They advise with respect to formulation of the policy for protection and conservation of the wildlife and any matter relating to the amendment of any of these schedules. So for example, if an animal has to be moved from Schedule 1 to Schedule 2, Schedule 2 to Schedule 3, Schedule 3 to Schedule 1, anything, the State Board of Wildlife will advise the state governments in this regard. Another authority under this act, which is very important, is the Central Zoo Authority. The Central Zoo Authority governs most zoos all over the country, because it is understood that zoos are equally important aspect of preservation of wildlife. This Central Zoo Authority generally consists of 10 members, including a chairperson and member secretary. The chairperson is generally the environment minister. This authority provides recognition to zoos and is tasked with regulating the zoos across the country. It lays down the guidelines and prescribes rules under which animals may be transferred among zoos nationally and internationally. Moving on to another authority under the Act, that's the National Tiger Conservation Authority.
So Ayush, sorry, just one question there with respect to zoos. I mean, does it also provide for, a certain standard to be maintained in zoos?
Absolutely. Absolutely. There are rules that have been laid down in this regard. I'm not going into detail with all the rules. So honestly, all these, sorry.
Practically, they may not be being followed, I think, as in looking at the state of affairs in most of the zoos. So I'm asking from that perspective that,
No,
is there
there are
something
guidelines that are
legally
laid
they're
down.
bound to?
There are guidelines that are laid down,
Okay.
and honestly, every act that we study right now, there are adjutant rules, there are notifications, there are numerous circulars that govern them. Where now, when you talk about implementation, India as a country, I feel there are many laws on paper. Like, we have a great system laid out. We have a lot of laws laid out which govern every aspect of our life in general. To what extent they are implemented, well, that depends a lot on institutional, whether there is institutional apathy to the issue or not. If the institution is unconcerned or is considering other aspects more important, primarily from a commercial or budgetary perspective also, then we will face these issues where implementation is not proper. We will face corruption issues as well. But that does not mean that the laws and the rules are not there. If you are aware of any violations, you can always approach the National Green Tribunal. You can approach the authorities themselves who will deal with the issue. Can I move on? Does that answer your question? Do you have any?
Yeah, it does. Yeah, thank you. So you can move on.
So there are two other authorities that I would like to discuss under this act. There is the National Tiger Conservation Authority, which was constituted following the recommendation of the Tiger Task Force and was constituted in 2005 for strengthening tiger conservation. More than 50 wildlife sanctuaries in India have been designated as tiger reserves and are protected areas under the Wildlife Protection Act, thanks to the recommendations of the NTCA. Because only on the recommendation of the NTCA can the central government declare an area as a tiger reserve. The last particular authority that I would like to bring to note here is the Wildlife Crime Control Bureau. The act provides for the constitution of the Wildlife Crime Control Bureau to combat organized wildlife crime in the country. It is mandated to collect and collate intelligence related to organized wildlife crime activities and to disseminate the same to state to apprehend the criminals. It establishes a centralized wildlife crime data bank. It assists state governments to ensure success in prosecutions related to wildlife crimes and advises the government of India on issues related to wildlife crimes having national and international ramifications and relevant policies and laws. Another thing to note is that under this act, any hunted wild animal articles or meat of a wild animal, it could be tiger skins, it could be ivory, anything imported into India also, and an article made from any of these shall all be considered as the property of the government. So no private person is allowed to own any of these now. There was a time when you could register it with the government and still keep it, but that time has passed. No people can now own wild animal articles.
Right.
If there are 4 schedules under this act, primarily which the Schedule 1, which deals with endangered species that need rigorous protection, Schedule 2, where animals are accorded high protection with prohibition on their trade, Schedules 3 and 4 that are not endangered, but they are protected. This includes protected species with hunting prohibited, but the penalty for any violation is less compared to the first 2 schedules. Besides this, we have Schedule 5, where the animals that are considered as vermins, small wild animals that carry disease and destroy plants and food, these animals are allowed to be hunted. There are only 4 such species of wild animals in India right now: common crows, fruit bats, rats, and mice. The act also has a 6th schedule, which provides for regulation of cultivation of a specified plant and restricts its possession, sale, and transportation. Both cultivation and trade of specified plants can only be carried out with prior permission of the competent authority. This is an overview of the Wildlife Protection Act, 1972, which was the first act that came out dealing with environmental protection in India. But soon enough, we had an act which was even more important, which is the Water Prevention and Control of Pollution Act, 1974. This act provided for the establishment of Central Pollution Control Board and State Pollution Control Board to act as watchdogs for prevention and control of pollution. Now, the Central Pollution Control Board and the State Pollution Control Board are very important authorities, which is why this act is so important. The act is the Act understands that water is an essential element of human living. So the purpose of the Act is to prevent and control the pollution of water, to maintain and restore the wholesomeness of water, establishment of boards, as I spoke about, for prevention and control of water pollution, and to confer on such boards powers to prevent and control water pollution and to maintain or restore wholesomeness of water. This Act is comprised of about 64 sections divided into 8 chapters. Chapter 1 will, of course, deal with preliminary aspects. Chapter 2 with the central and state boards. Chapter 3 with joint boards. Chapter 4 with the powers and functions of the board. Chapter 5 with prevention and control of water pollution. Chapter 6 lays down the provisions related to funds, accounts, and audit. Chapter 7 lays down penalties and procedure for penalties and procedure related to any offenses under this Act. And Chapter 8 contains miscellaneous provisions. Let's speak about Section 1 for a second. There are some important definitions that we come across here. Section 2, under Section 2, which will define board, central board, who is a member, occupier, pollution. What is pollution? Let's see what is pollution, for example. Section 2E, pollution is defined as something that means such contamination of water or such alteration of the physical, chemical, or biological properties of water, or such discharge of any sewage or trade effluent or any other liquid, gaseous or solid substance into water, whether directly or indirectly, as may or is likely to create a nuisance or render such water harmful or injurious to public health or safety, or to domestic, commercial, industrial, agricultural, or other legitimate uses, or to the life and health of animals or plants or of aquatic organisms. So you can see that the definition of pollution is very wide. It covers almost any form of pollution that can go into the water, and the boards are generally tasked with monitoring this. If you look at, let's go to the boards, because that's a little important. The Central Pollution Control Board is constituted under this Act. Section 3 of the Act provides for the constitution of the Central Board. And within 6 months from the commencement of the Water Act, by notification official gazette, the central government appointed a board. Now, the CPCB was appointed primarily for operations in the state, when it was in the states of Assam, Bihar, Gujarat, Haryana, Himachal Pradesh, Jammu and Kashmir, Karnataka, Kerala, Madhya Pradesh, Rajasthan, Tripura, West Bengal, and in union territories. Later on, the Air Act again expands upon the functions of the Central Pollution Control Board and the State Pollution Control Board. And I shall come to that when we move to the air pollution aspect as well. Now, the Central Pollution Control Board generally consists of a full-time chairperson who is an expert in environmental matters nominated by the central government. It also contains, more importantly, it also contains members from representing local authorities, from members of the state boards. It also contains members nominated by the central government to represent the interests of agriculture, fishery, or industry, or trade, or other interests. So the board is a very holistic body where various interests are represented, and it is given certain powers and certain functions. The main function of the central board, of course, is to promote cleanliness of streams and wells. According to section 16(1), the 16 clause 1, the central board may perform all or any of the following functions. There are multiple functions laid down, but I'll go through some of the more important ones, which is to advise the central government on any matter concerning prevention and control of water pollution, coordination of activities of the state pollution control boards and resolution of disputes between them, performance of functions of state boards as well, as may be specified in any order, to collect statistical data relating to water pollution and to take necessary steps for effective prevention, laying down, modifying, or annulling in consultation with states concerned the standards for water in streams, wells, etc. Besides that, the Central Pollution Control Board also establishes and recognizes laboratories for analysis of samples of water from any stream or well. The Water Act also lays down, constitutes the State Pollution Control Board. the Section 4 of the Water Act provides for the constitution of the State Pollution Control Board, where the state government, by notification in the official gazette, constitutes the State Pollution Control Board to exercise the powers conferred under this act. Again, the state board generally consists of a chairperson nominated by the central state government, but such person has to have special knowledge and practical experience in environmental matters. Besides that, there are members nominated by the state government to represent the state government, to represent local authorities functioning within the state, to represent the interests of agriculture, fishery, industry, trade, or other interests, which in the opinion of the state government ought to be represented. Another important aspect of the state board is that the state board's function is to plan a comprehensive program for the prevention, control, or abatement of pollution of streams and wells in the state, and to secure execution thereof. It is meant to advise the state on any matter concerning prevention, control, or abatement of water pollution. It lays down, modifies, and standards for sewage, trade effluents, etc., which are resulting from discharge of effluents, and to classify waters of the state. Various methods of how to deal with sewage treatment, how to deal with trade effluents, with regard to conditions of soil, climate, water reserves of different areas, are all considered by the State Pollution Control Board before forming any guidelines or before forming any rules in this regard. So to make they also have the power to make, vary, or revoke any order for the prevention, control of abatement of discharges of waste into streams of well. They can require any person concerned to construct new systems for disposal of sewage and trade effluents, or to modify, alter, or extend any such existing system to adopt remedial measures as are necessary to prevent, control, or abate water pollution. Besides that, there are functions it may be entrusted to by the central board or the state government, which it has to fulfill. Besides this, there is an option for joint boards, where two or more governments of contiguous states, by an agreement, can constitute a joint board for the states concerned. A joint board may be constituted by the central government or one or more governments of the states contiguous to such union territory or union territories either. It's not important to go into the details because most of the powers and functions of the joint board are similar to that of the State Pollution Control Board. An important aspect is the penalties that are under this, penalties and offenses that are under this act. Failure to comply with any directions under the act, specifically those under section 20 clause 2 or 3, or orders issued by the
before you come to the penalties, that is the Pollution Control Board also some sort of adjudicatory body? As in, if tomorrow I do find some instances of water pollution, am I as a citizen eligible or allowed to approach the board, or would I have to go to NGT?
No, you will have to go to NGT. It is the duty of the board to monitor the trade effluents, etc. You can always write representations to them that, or bring to their notice that there are violations going on, but it is not an adjudicatory body. It is a regulatory and monitoring body. It lays down guidelines, it lays down standards, and it deals with granting permissions to industries, monitoring whether they are in line with the clearances that have been given to them, granting consents, monitoring the consents that have been given to them to operate and to function. So moving on to some of the penalties, etc. Failure to comply with the directions under this act, which are issued by the boards, are punishable with imprisonment for a term which may extend to 3 months, or a fine which may extend to 10,000 rupees, or with both. Additional fines which may extend to 10,000 rupees for every day during which failure continues after the conviction of first such failure is also provided. If anybody fails to comply with an order under, let's say, section 33 or 33A, such person can be punished for imprisonment which will not be less than 1 year and 6 months, but which may extend to 6 years. The fines are also considerably higher in this. Therefore, we can see that there are significant criminal liabilities attached with water pollution that have been laid down under this act. there are penalty for numerous other acts as well, which are laid down, including any damage of property or work or property belonging to the board, failure of furnishing information to officers or employees of the boards, giving wrong information, which they are required to under the Water Act, knowingly or willfully making statements which are false in any material particulars, etc. So this broadly covers what the Water Act is, what the Water Act does. Another aspect that I'll shortly put on is that the Water Act also lays down provisions for the Central Pollution Control Board and the State Pollution Control Board to prepare to have central water laboratories or state water laboratories, which will test samples of water or sewage or trade influence for analysis or tests. So the data collected by these laboratories is then used in prosecution or in monitoring by either the Pollution Control Board or the National Green Tribunal as well. The next major act that we'll be dealing with here, which was the next in line, was in 1980. That was the Forest Conservation Act, which was aimed to check deforestation, diversion of forest land for non-forestry purposes, and to promote social forestry. Now, there is a very basic criticism of the Forest Conservation Act, that it was not meant for conservation of the forest per se. Rather, the aim of the Forest Conservation Act was to bring forests under the control of governments, that only they can decide how the forest and the resources of the forest are to be taken or utilized. Let's go to some basics of what the Forest Conservation Act does. One of the major aspects is Section 3 of this Act, where the central government has the power to constitute an advisory committee to advise on matters relating to preservation of forests. The purpose of this act has always been to foster recognition of the forest as a common heritage and to promote sustainable forest development. The power to carry out directions of the central government, etc., under this act is provided under Section 4 of the Act. How far down are we? I think I'm running a little short of time also, because I believe there is one more speaker. So let me move a little faster. So this is the basic idea of forest conservation comes from the Forest Conservation Act, where the state takes control of the forest. It checks what forest resources are being taken from the forest, and it lays down rules and guidelines on how the forest is to be administered, including appointment of forest officers, etc. The next major legislation that we'll be dealing with is the Air Prevention Control of Pollution Act 1981, which is aimed at checking air pollution via the same Central Pollution and State Pollution Control Boards. So an important definition under the Air Pollution Act is Section 2A, which defines air pollutants. Air pollutant is particularly defined as any solid, liquid, or gaseous substance which may cause harm or damage the environment, humans, plants, animals, or even damage property. Through the 1987 amendment, noise has been added as in the list of harmful substances as well. The Air Act defines air pollution as the presence of any dangerous pollutant that makes the air unbreathable. Now, under this act also, Section 2G, the Central Pollution Control Board is set up. Now, once this act came out, then Central Pollution Control Boards were set up in every state. Under Section 2G of this act, the Central Pollution Control Board's powers were extended to all of India to carry out the directives of the CPCB under the act, and also for setting up of state pollution control boards for individual states, as I measured. Now, the key features of this act are that the CPCB advises the central government on air and air pollution related issues. They cause research about causes and impact of air pollution. Include the State Pollution Control Board does similarly for the state governments. They spread awareness to stop air pollution. And the boards monitor air quality and control air pollution. There are numerous rules, regulations that have come out since then, which deal with this issue. One of the major issues in this is on how air quality is monitored is through an air quality index. The major pollutants recognized under the Air Pollution Act are particulate matter PM10, particulate matter PM2.5. These are tiny particulate matters in the atmosphere around us. Harmful gases such as nitrogen dioxide, sulfur dioxide, carbon monoxide, ozone, ammonia, lead. These are generally monitored by the pollution control boards through air quality monitoring systems and various other methods as well. They laid out emission controls for various industries. And again, permissions need to be taken before any industries are being set up in order to understand what the effects of such industry is going to be. The major important act in environmental legislation, again, is the Environment Protection Act 1986.
Just one question before you move to the EPA.
Sure.
You know, under the Air Act, you're saying that, I mean, every year around Diwali, we hear news reports about, you know, stubble burning in Punjab, which leads to a lot of pollution in North India, predominantly Punjab and Delhi. So are there any like rules and provisions in the Air Act which would help to control this, or is there some exception that is made for stubble burning?
There is no exception under the Act. It is just a failure. We are consistently failing. It's also important to note that we have constantly come out with plans and programs also to control air pollution. There's a National Clean Air Plan. There are state action plans that have to be prepared, city action plans that have to be prepared by state governments, non-attainment cities, etc., have been identified where air pollution is severe. But again, like, the implementation is a major issue. Pollution is such a pervasive issue that it is very difficult. But there is also recognition that pollution is also a seasonal issue. Like in winters, it does become a more important issue. Now, it is the job of the Central Pollution Control Board, the State Pollution Control Board, to put out scientific methods of dealing with this.
Right.
Often, these are hijacked by a lot of commercial and political interests. Methods, for example, recently, there has been a lot of talk in Delhi about smog towers, etc., being put up in the city, where scientifically all over the world, there is a consensus that these smog towers do not work, but it's still being done. We have these odd even days in Delhi that came out.
Right.
To some extent, they are helpful at some points of the year, but when most required, at that time, they are not being helpful. So the issue is still very prevalent, and it is being monitored by the Central Pollution Control Board. If the programs and plans that have been laid down are followed rigidly, you know, the policies that are being laid down are followed rigidly, I'm sure we can see positive change, but it needs political will and it needs commercial will as well. To move to the Environment Protection Act. Just a moment. Yes, the Environment Protection Act, enacted in 1986. This was enacted with the objective of providing protection and improvement of the environment. It empowers the central government to establish authorities charged with the mandate of preventing environmental pollution in all its forms and to tackle specific environmental problems that are peculiar to different parts of the country. This act is honestly one of the most comprehensive legislations with the idea to protect and improve environment. Now, again, like I said, the genesis always lies in Stockholm Conference. I'll go through some of the salient features of the act. Please excuse me, I have a bit of a cold. The salient features of the act. First, let's see what are the powers of the central government. The central government under this act has the power to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment in coordination with state governments. The central government is empowered to plan and execute nationwide programs for prevention, control, and abatement of environmental pollution, lay down standards for the quality of environment in its various aspects, lay down standards for emission or discharge of environmental pollutants from various sources, restrictions of areas in which industries, operations or processes or class of industries, operations or processes shall or shall not be carried out subject to certain safeguards, appointment of officers under the Act and giving them corresponding powers and functions. The Act provides a restriction of pollutant discharge in that no individual or organization shall discharge, emit, or permit to discharge, emit any environment pollutant in excess of prescribed standards. It also says that no individual shall handle or shall cause to be handled any hazardous substance except in accordance with the procedure and complying with the safeguards as prescribed. It empowers the central government for entry and inspection, where they may, for the purpose of examining any equipment, industrial plant, record, register, document, or any other material which may furnish evidence of the commission of an offense under this Act. It establishes environmental laboratories where any functions entrusted to such a laboratory, which includes monitoring, data analysis, etc., can be done. An important aspect of this are the offenses. If an offense under this Act is committed by a company, every person directly in charge of the company at the time of commitment of offense is deemed to be guilty, unless proven otherwise. So one important aspect is that it shifts the burden of proof upon the offender, who wasn't, particularly in the case of a company, who was the person in charge of the company. The penalty can be anything from imprisonment of up to 5 years or a fine up to 1 lakh rupees or both. The issue with this Act at the beginning was that there is a centralization that is done. That while such wide powers are provided to the center, the state governments do not have equal powers. And therefore, like we discussed, due to political or other reasons, there is always a chance of arbitrariness, misuse. The Act itself does not talk per se of public participation, which is an important aspect of environmental rule of law. Many other pollutants also are not considered by this Act, and it deals with only the specific pollutants that we discussed. But under this Act, various other rules and notifications have come out, which are of extreme importance. Most important are 2 notifications. We have the environmental impact assessment notifications and the coastal regulation zone notification. Okay. So the environment impact assessment notification is where the EIA process or environmental impact assessment process was laid down. This is a process for evaluating the likely environmental impacts of a proposed project or development, taking into account interrelated socioeconomic, cultural, human health impacts, both beneficial and adverse. Now, because of this notification, any proposed project generally has to do an environmental impact assessment. This process involves screening of the project, where the project plan is screened for scale of investment, location, type of development, and if the project needs statutory clearance, scoping, which is the project's potential impacts, zone of impacts, mitigation possibilities, need of monitoring, collection of baseline data, environmental data of the area, of the study area, impact prediction, mitigation measures in an EIA report, which means that the EIA report has to include the actions and steps for preventing, minimizing the impacts of the probable environmental damage or loss. The most important part of this notification is public hearing, that on completion of the EIA report, the public and environmental groups living close to the project site may be informed and consulted. Now, this has been widened to a large extent by the National Green Tribunal and the Supreme Court as well, when they say that environmental pollution is an issue that affects everybody. Therefore, in a public hearing, you don't necessarily have to be living close to the project. If it is affecting the environment, any person can be part of the public hearing. Now, the Impact Assessment Authority along with experts, consult the project in charge along with consultants to take the final decision, keeping in mind EIA and EMP. So not just an environment impact assessment has to be done, an environment management plan also has to be prepared. The EIA notification speaks about the various phases of implementation of the projects that are monitored, assessment of alternatives, delineation of mitigation measures, and EIA report, where possible alternatives are identified, where environmental attributes are often compared, which cover both project location and process technologies. Risk assessment is done where inventory analysis, hazard probability, and indexing is made. This has been. I'm sorry. Is there some?
Yeah, no, there was some disturbance. We put them on.
Sure. Thank you. I thought there was a question that was being done. Now there was this EIA notification has been amended also. In 2006, the amendment was done where the EIA cycle was reduced to screening, scoping, public hearing, appraisal. And projects were identified into categories like category A project, which require mandatory environmental clearance and they do not undergo the screening process. Category B projects, which undergo screening projects and are classified into two types. Category B1, which mandatorily requires environment impact assessment, and category B2, which do not require environment impact assessment. So category A and category B1 undergo the complete EIA process, whereas category B2 projects are generally excluded from the complete EIA project. I'm not going to go into things like the importance of EIA because I think that's quite it's quite obvious, as I say, res ipsa loquitur, as they say. But there are certain shortcomings. There are several projects.
Aayush, could you tell us like what would be category A or category B? Some examples of category A project.
Sure. Category A project would be, let's say, an industry where there is going to be effluents that are going to be generated. Let's say a power plant of some sort, thermal power plant, or a coal project. Anything like this is a category A project where there is mandatory EIA that has to be done. Where what's a category B2 project are mostly eco-friendly and small scale projects, where we do not anticipate a lot of effluents, trade effluents, etc., which are going to be emitted, or where a lot of pollution is going to be caused, right? So let's say there is a small weaving mill. A weaving mill would be sort of a category B2 project, unless it involves dyeing as well, because dyeing means that there are chemicals, etc., being used. But otherwise, this would be a category B2 project. The second notification that I wanted to speak about was the Coastal Regulation Zone, CRZ notification. Now, the first CRZ notification came in 1991, which was then amended. Then a new notification came in 2011, and then a new one has recently come out in 2019. I'll go through what the basic idea of the CRZ notification is. The importance of it, the reason why it's there is for protection of ecologically sensitive areas like mangroves, coral reefs, which act as shields against tsunamis and cyclones, improving the lives of coastal communities like fishing communities, preparing resilient measures for mitigating impacts of climate change and high intensity cyclones, and to balance development with conservation of the coastal regulation zone, with the coastal environment. Now, under this, again, there are classifications that are made. There are CRZ1 areas, there are CRZ2 areas, there are CRZ3 areas, etc. 2019 Act, which is presently there under, let's first do the CRZ 2011, because this was the one which lasted for quite a while and has been there for the recent times, where CRZ1 were ecologically sensitive areas like mangroves, coral reefs, biosphere reserves, etc. In these areas, no construction and no projects were permitted, no development zone, except for very few sensitive projects. This also included the area between the low tide line and high tide line, like the intertidal zone, as they say. CRZ2 areas were areas which were developed up to the shoreline and falling within municipal limits, including built-up area, villages and towns, which are already established. CRZ3 areas were areas which were relatively undisturbed and do not fall either in category 1 or 2, but included rural and urban areas. Now, in these areas, between 0 to 200 meters from the high tide line, there is a no development zone. And only certain activities like agriculture, forestry, salt manufacture, etc., besides projects of Department of Atomic Energy and mining of rare minerals was allowed. And then we have the CRZ4, where the aquatic area from low tide line up to territorial limits is classified as CRZ4. There is no restriction on traditional fishing undertaken by local communities, but no untreated sewage or solid waste is allowed to be dumped in these areas. This 2011 notification was a very comprehensive and a very strong notification that came out. It was considered in general to be very useful for protection of the environment. It laid down the necessity of preparation of a coastal zone management plan, where all these areas would be identified. What is CRZ1, what is CRZ2, what is CRZ3, where do communities live, what areas do fishing communities use, etc. But in 2014, there was a Shailesh Nayak committee, which was formed, which gave a report on CRZ, which basically suggested relaxation on the terms set up in CRZ 2011 notification. The major objective behind it was to boost tourism, port construction, and real estate. The committee suggested dilution of the regulatory powers of the central government in the coastal areas and transferred some of those to the state governments. Based on the suggestions of this committee, the 2019 notification came out. The 2019 notification substantially waters down the 2011 notification. Even in no development zone, etc., even in close to the coastal areas, there is permission of ecotourism activities and non-polluting industries, etc., can be set up in areas in CRZ2, for example. State government has been given a lot more power under the 2019 notification as compared to 2011, where the central government had most of the authority. This takes us through these two important notifications. The last statute that I would at least like to point out is the biological diversity.
One point that when you say coast, I mean, our general understanding of coast is near the sea. So even CRZ is only applicable to the sea, right? Not with respect to all water bodies.
Not all water bodies, but there are certain inland bodies as well, deltas, etc., where it is applicable.
Okay. But like not like construction near the riverbed or construction near a lake shore would be falling under some other act, not under your CRZ regulations.
So the coastal areas of creeks, seas, bays, even rivers and backwaters that get affected by tides up to 500 meters from the high tide line form a part of CRZ, coastal regulation. So inland rivers, etc., which do not get affected by tides, etc., up to 500 meters, they are generally not part of CRZ regulations.
And I know before you just go to the Biodiversity Act, considering that you already had the Water Act and the Air Act in place, what additional protection has been provided by the EPA? I understand there's this environmental impact.
There's a lot of monitoring that has increased, and areas which are no development zones primarily which were created. The major understanding was that this is a very sensitive ecosystem. Which even the Water Act and Air Act did not contemplate a lot of the issues that were arising in these areas. There was a necessity of understanding that what these areas are, who live in these areas, which is where the preparation of a coastal zone management plan comes in. And there was an understanding that there are certain parts where you cannot have any development, which was why the CRZ notification was specifically brought out as compared to the more generalized Water Act or Air Act provisions.
And is there any connection between Bhopal gas tragedy and the EPA, considering that the tragedy happened in 85 and this EPA came out in 86? Like, was it as a result of this tragedy and due to some shortcomings or certain paths that the government may not have had to pursue the offenders that EPA might have come up?
So the genesis of EPA is not the Bhopal gas tragedy.
Right.
It is the Stockholm Declaration of 1972.
Okay.
Definitely, it was in the wake of the Bhopal gas tragedy where the government realized that it had to implement the guidelines of the United Nations Conference on Human Environment, which is the Stockholm Conference. And after that, after that, this act was definitely enacted. But with respect to Bhopal gas tragedy, there are the major work was done by the Supreme Court and the courts, where they brought out principles of absolute liability, no fault liability, which are not part of the Environment Protection Act per se. They definitely form some part of the National Green Tribunal Act, which Maitreya will discuss. But so I would not say that the Environment Protection Act is because of the Bhopal gas tragedy. I would say the genesis is much earlier, but definitely the impetus to immediately bring something out was the Bhopal gas tragedy. That it was such a major environmental tragedy that the government, I think its hand was also forced that, okay, we do need to bring out something right now.
So, and Ayush, we have one question, not a legal question per se, but more a practical one, that how can a common man, will it be possible for a common man to measure air pollution, and is there any process, method, cost for the same? Would you be aware of this?
You can do it if you have the material, but otherwise, generally, like I mentioned, there are environmental laboratories, there is the central water laboratories, and there are various state accredited laboratories, etc., which are set up, which you can approach for taking samples, and you can get them tested there.
And you have the AQI in place also, as in that is something that is constantly.
Yes, so air quality data of non-attainment air cities, etc., they are available through almost, they're meant to be available online on the websites of the pollution control boards. That the pollution control boards are to constantly maintain data of what the air quality of a particular area is, particularly non-attainment cities. They have to have CAAQMS, continuous ambient air quality monitoring systems in place. So all that data is collected and put into a centralized database, which is available for everybody. Besides that, there are a lot of private tools also. If you go online, you will find air trackers, air quality trackers. You will find apps which track air quality, where you can track air quality across the country. What is the air quality where, which take data from these monitoring stations, air quality monitoring stations, and just put it online.
I hope that answers your question, Sujit. So yeah, you can proceed with, come to the biological diversity.
Sure. So this is the last act that I will be discussing before I hand the floor to Maitreya. I think I've already gone way beyond I was meant to go.
No, we'll extend the session by maybe half an hour. We'd love to hear you both.
The Biological Diversity Act 2002. This act was enacted for the conservation of biological resources, managing its sustainable use, and enabling fair and equitable sharing benefits. The act prohibits any person or organization from obtaining any biological resource occurring in India for its research or commercial utilization. It sets up the National Biodiversity Authority, state biodiversity boards, and biodiversity management committees at a local level, through which the biodiversity is protected. The National Biodiversity Authority is the only authority which can give permission for example, if you want to make an intellectual property claim on any invention based on research made on biological resources obtained from India, you have to take the permission of the National Biodiversity Authority. The biodiversity management committees at the local level help in identifying various species, various biological resources, etc., in certain areas and creating databases. They help in notification of threatened species, prohibition or regulation of their collection, rehabilitation, conservation. The central government also designates institutions as repositories for different offenses of biological resources. There are certain exemptions from that are excluded from the Indian biological resources. These are normally traded as commodities, which are these are things that are generally used by cultivators, like livestock keepers, beekeepers, traditional healers, like practitioners of Ayurveda or Hakims, etc. They are exempted from this act. Let's go to the basic idea of the National Biodiversity Authority. It is the statutory body that performs facilitative, regulatory, and advisory functions for the Government of India on the issue of conservation and sustainable use of biological resources. It's located in Chennai, headquartered in Chennai. Generally, its function is to create an enabling environment to promote conservation and sustainable use of biodiversity. It advises the central government in regulating activities and issuing guidelines for access to biological resources and for fair and equitable benefit sharing. It takes necessary measures to oppose grant of intellectual property rights, as I mentioned earlier. It advises state governments in selection of areas of biodiversity importance to be notified as heritage sites and suggests measures for their management. Besides this, we have state biodiversity boards, which are established under Section 22. These state biodiversity boards advise the state government on matters relating to conservation, sustainable use, or equitable sharing. They also regulate granting of approvals or request for commercial utilization or biosurvey and bioutilization of any biological resources by people in the state. Lastly, we have the biodiversity management committees, which are local bodies which are for the purpose of promoting conservation, sustainable use, and documentation of biological diversity, including preservation of habitats, conservation of land races, folk varieties and cultivars, domesticated stocks and breeds of animals, microorganisms, and chronicling of knowledge relating to biological diversity. The main function of the BMC is to prepare a people's biodiversity register in consultation with the local people. This register contains comprehensive information on availability and knowledge of local biological resources, their medicinal or any other use. And lastly, the important part is the setting up of biodiversity heritage sites, where the state governments, in consultation with local bodies, notify areas as biodiversity heritage sites. These are areas that are unique, ecologically fragile ecosystems. They can be terrestrial, coastal, inland water, or marine based, but they must have rich biodiversity comprising of richness of high endemism, maybe presence of rare and threatened species, keystone species, species of evolutionary significance, etc. So if any of these things are present, the state government can notify it as a biodiversity heritage site. This is a brief overview of the environmental laws in India. I have discussed all the major statutes that are here, some important
question that with respect to these notified sites, could you just give us an example of a few that are already notified?
Sure. There is in Bengal, I'm aware that there is the Chilkigarh Kanak Durga area, which is notified as a biodiversity heritage site. In Maharashtra, there is Glory of Allapalli, which is notified as a biodiversity heritage site. So these are at least two. In Goa, there is Purvatali Rai, which is notified as that. In Madhya Pradesh, there are Naro Hills.
Right.
So these are some biodiversity heritage sites which have been notified by the state.
Right.
I'll hand the floor over to Maitreya, who will take this forward. He will give you, now that you have an idea of what the laws are, how these laws can be taken up, what is the authority that is going to deal with these things. Maitreya, the floor is all yours. Thank you, everybody, for a patient hearing. I realize I've gone way beyond what I was meant to discuss. It's just that this is a very vast subject, and I feel like I still haven't covered 99% of it. But thank you for giving me a
Thank you. And hope we can have another session to cover the remaining 99%, because it's been a very interesting talk. And these are things we've heard but not aware of, that what is the law behind it. We've heard of what AQI is, but what is the law involved with respect to which AQI is required to be given to the public. So I think all these were quite helpful. And over to you, Maitreya.
Thank you so much, Kunal. Thank you, Aayush. That was quite a rigorous undertaking that he has led us on. And it's great because it perfectly sets the segue for my part of this conversation, wherein I try to analyze the evolution of the NGT, because I think that is really key to understanding why it is the way it is, or why it was designed by a statute, by an act of parliament in 2010 to be the kind of tribunal that it is. And I'm going to try to do this through an analysis of the cases, because as Aayush has pointed out, there are numerous legislations that exist, but how do these get reflected on the ground? I think that is something that is of key importance, because there's no dearth of legislation, so to speak. There are sufficiently broadly phased provisions which allow for a lot of governmental intervention, but how much of that has actually taken place is something that I am going to attempt to show you guys. I have prepared a small presentation, so if I have a permission, I'm just going to share my screen.
Maitreya, I have made you co-host. You can try sharing.
Okay, fantastic. Can you guys see?
Yeah, we are able to see your screen.
Okay, fantastic. Right. So my talk is essentially divided into 3 chapters: a brief history of the jurisprudence, an evolution of the NGT, how it is what it is right now, and how it currently works. If you want to run a case in the NGT, what do you essentially do? What can you do? So if you look at the NGT website, this is the kind of boring screen that they give you on history of NGT. There's a lot of words here, but to be honest, it doesn't really do justice to what I think is a very interesting history of the NGT. You can read it. I won't read it out to you. I'm sure some of you might fall asleep if I do that. So couple of key points. It's relating to the NGT was formed for expeditious disposals of cases relating to environment protection. They have a multidisciplinary jurisdiction. They are not bound by the procedure laid by the CPC. They have an establishment in 5 places across the country, 5 benches. There's also a provision for circuit courts, circuit tribunals to sit, but that really doesn't happen so much anymore. But anyway, this is just the brief history according to the NGT website. What is more important, however, is to see how the jurisprudence has evolved from the Supreme Court, because as some of you might know, the NGT is not very old. It was established just 11 years ago. And in 11 years, it's managed to do a significant amount of work revolving around environmental protection. But the genesis always goes back to the Supreme Court. So a brief history of jurisprudence. 3 aspects are really key in what led to the formation of the National Green Tribunal. Firstly was a understanding by the court that the right to environment is fundamental. It's part of Article 21. Secondly is the evolution of absolute liability. You spoke of the Bhopal gas tragedy, and I'll come to that in a minute. But it was in fact a very key turning point in the Indian consciousness surrounding environmental laws and how we look at them as a society. So definitely that is also a crucial part. And then the principles that govern the NGT. The NGT is not akin to just another administrative tribunal or just another tribunal, say for meant for expeditious disposal of a particular kind of case. It is in fact a much more principled institution. I feel it's the ethos, the core of it is much more principled than say an income tax appellate tribunal, a national company law tribunal, debt recovery tribunal. These are all very commercial, very specific tribunals, but the NGT is more principled, and I'll elaborate on that in just a minute. So starting with the fundamental right to environment. Now this case is very unique. Article 21 is the right to life and personal liberty, as many of you might know. And it was the first time in this case, Subhash Kumar versus State of Bihar in 91, that the Supreme Court elevated the right to a clean and healthy environment as part of Article 21. What happened in this case is essentially regarding, as you can see, prevention of pollution in the Bokaro River. It was caused from slurry being released by particular industries. And as you can see, this was the ratio that was passed. What I find particularly interesting in this case, however, is that the court did not award any sort of relief to Mr. Subhash Kumar, because it said that although this case is hailed as like one of the big revelations in Indian jurisprudence with regards to right to environment, the particular petitioner in this case didn't receive any relief, because it was held that he was filing the case with a personal interest, because he was an interested party in this, and it wasn't akin to, you know, the in the 80s how we saw the Bandhua Mukti Morcha movement and the whole PIL movement brought in by Justice Bhagwati and Krishna Iyer. So this case was sort of not in fitting with that. So although they did the Supreme Court did hold all these, elevated notions of environment and the protection of environment and the sanctity of it, the particular relief was not offered to the petitioner.
Right.
So I've always found that pretty interesting. And as you will see, this seems to be a sort of recurring theme with the Supreme Court, that a lot of these words are said and a lot of phrases of high eloquence and wonderful to listen to, but how much of that is really translated on the ground is something that I've always been particularly interested in. So in Subhash Kumar, we saw that the particular relief was not provided to the petitioner, but the case is still regarded as a huge victory for the environment.
Maitreya, so this one question that in case of Subhash Kumar, the only reason for not providing relief was the fact that he was an interested party, as in the fact that environmental damage had happened was acknowledged, or
it was acknowledged,
right.
but see, so as you might know, fundamental rights are enforceable. The majority of them are enforceable only against the state.
Right.
And state as per Article 12 of the Constitution. Now, of course, that has also through various jurisprudence been expanded, particularly in the educational sphere. We've had amendments to Article 15 and 16, which have elaborated the sort of scope of the applicability of fundamental rights to even some sort of minority institutions or some sort of private institutions if they're partially funded by the government. I mean, I won't get into that technicality, but one of the other main reason was also that the particular respondents in this matter were not classified as under state. So the court the maximum they could do, or rather they chose to do, was to pass these orders, but not have any sort of punitive action undertaken. Then comes the issue of, but regardless, I mean, I must make it clear that Subhash Kumar was a big milestone in environmental jurisprudence. Then we have the oleum gas case, which is, and Charanlal Sahu. Both of these really put the concept of absolute liability in the domain of Indian jurisprudence. Now, what is absolute liability? Some of you who have studied law might be aware of the concept of strict liability. The case of Rylance versus Fletcher, it goes back more than 130, 40 years ago. And that essentially was the principle by which courts were still functioning up until the 80s. What was strict liability? It was essentially when a person is carrying on a hazardous activity, they are liable for any damage caused by it, subject to certain exceptions. So if it was an act of God, if there was force majeure, if a third party intervention had led to some kind of accident, so on and so forth, the person carrying on that hazardous activity was not responsible. Now the courts, this is where the aspect of Bhopal gas tragedy comes in, which I found very interesting. The courts in the nation's consciousness was shaken by the Bhopal gas tragedy. And we had then started to witness how even the acts that were passed regarding the air pollution and water prevention and control of pollution acts were passed. The boards had still not been established, the pollution control boards. There was a lot of sort of activity that had taken place on legislature, on paper, but its implementation was still not done as per what was mandated. So the Bhopal gas tragedy really shook the nation's consciousness, and it's evident that it did in the that translated to the Supreme Court also feeling a sense that, okay, we should really step up our game, and this cannot sort of happen again. So Bhopal gas tragedy happened in 1984. In 1985, this oleum gas leak happened, and that really was like, oh my God, now this is happening again. Although in scale it was much smaller than the Bhopal gas tragedy, it was still another gas leak. Where oleum gas did cause the death of.
If I'm not wrong, I think this happened in Delhi, so closer to the capital.
Yeah, it did happen in Delhi. It did. In fact, it's very interesting. Mr. MC Mehta, who I'll get in about details in just a minute, he had already filed a case against Shriram Fertilizer. I think I'll just open the next screen. Yeah. Shriram Food and Fertilizers were already a case was existing, and during the existence of the case, there was this gas leak. Okay. So the respondents' main challenge was that you cannot have any sort of liability, because the initial case was not relating to this,
Right.
so they tried to get away on a technical ground. But anyway, the Supreme Court evolved this concept of absolute liability, which is very, I mean, some might say it's anti-development, some might say, it's anti-economical, so on and so forth. But I think it's a tremendous piece of, jurisprudence to have evolved something like absolute liability, to go against completely what has been the common thinking process of the jurisprudence for hundreds of years. And as you know that being a lawyer, that these kinds of principles to overturn, you need some kind of serious judicial will. And to come up with something like absolute liability, that regardless of what happens, whatever be the reason, even a flood happens, even earthquake happens, but if you are carrying on that activity and because of that some people are harmed, then that hazardous activity is your responsibility and you should accordingly. So it's in my opinion, it's an incredible sort of what's it called, judicial intervention and amelioration of the right. But again, in similar vein, how much relief was provided to these citizens is something that is again a matter of I would say something that we need to introspect on, because this is again a recurring trend. Not sufficient sort of relief was not provided. There was minimal relief, but who's to say how much a life is worth when it's lost to something like an industrial accident? So these are questions that continue to plague our judiciary, I would say, and even the NGT, as I will get to in a minute. Now, some of you might know MC Mehta. I feel the need to mention his name because without him, environmental jurisprudence would not be what it is today. These are just some of the cases, not even, I think, a fraction of the cases that he has done. And as you can see, the dates, they're all in the 80s, the 90s, so that was really, I think the socio-cultural context, the socio-political context of the country is also very important, because we had, the sort of totalities of the emergency period, and then the sort of emergence of that alternative united front challenging Mrs. Gandhi, and then the re-emergence of Mrs. Gandhi, then her assassination. So it was a really politically charged time in this country. And for someone like MC Mehta to take the mantle for environmental jurisprudence, I feel he definitely, whenever anyone has a talk on environmental jurisprudence and the growth, you have to say the name of MC Mehta. And of course, there's several others, there's Sundarlal Baugan of the Chipko movement, and where Meda Patkar of Narmada Bachao Andolon. There's so many doyens and stalwarts of the movement. But I feel in terms of the legislation, the jurisprudence part, going to court and fighting, there's none other than, the legend, Mr. MC Mehta. So I would request all of you to just, maybe read up on him sometime. I can't possibly cover the
I think any law students probably like done any
absolutely
on environmental law will definitely.
Absolutely, even constitutional law for that matter.
Yeah.
You cannot not have Mr. MC Mehta's name. Yes. So and these cases have, some of them have just become sort of things of legend. Currently, like you have the Delhi air pollution case, which is still going on since 1985. There must have been, I don't know how many thousands of orders last I checked passed in it. So he's a legend. I think that's enough. Now coming to the aspect of the development of principles of NGT, right? Now, as I said, the NGT is not akin to just another tribunal, because in section 20 of the Act, you have these three principles deeply embedded to it. Like any order passed by the court has to be in keeping with these three principles. And what are these three principles? The firstly is principle of sustainable development, precautionary principle, and polluter pays principle. And this was first put out in Vellore Citizens Forum. Vellore Citizens Forum, as some of you might know, in fact, is again a MC Mehta case in which he was helping the people of Vellore. It was filed due to release by industries, by tanneries, and the Supreme Court held that the principle of sustainable development, and two other principles, but to begin with the principle of sustainable development, because it's so important. One personal sort of what can I say, grievance that I have with this principle is I think it has not kept up with modern times. I think when it was enunciated, the understanding was that there has to be a balancing between economy and ecology on both sides. And this notion has been reiterated across benches for many years now. But I think now we've come to the understanding that you cannot have you cannot have economy without ecology. That you cannot damage the environment and expect massive GDP. That in the long term, and not even the very long term, in the moderate long term, the economic costs of climate change far exceed any sort of temporary gains that you might gain by destroying the environment. In the long term, economically, climate change is going to cost the global economy trillions of dollars, and India is at the forefront of it because of our geographical situation, because of how dependent the economy is on things like agriculture, and what a vast number of people of our country are dependent. So we are definitely need to reassess this, but again, more on that later. In Vellore Citizens Forum, coming back, a very interesting thing was held. Now, compensation was awarded. Now, this is one of the first cases in which considerable compensation was awarded, but based on the articles of the Constitution. The polluter pays principle had not really received much recognition in this country as of yet. As some of you might know, the polluter pays principle goes back to the 70s when it was put out by I think the OECD first, or some United Nations organization. And from there, it's evolved in different countries in different ways, as we'll see in India also, it's evolved in a pretty unique way. But the Vellore Citizens Forum was a unique case because under 48A and 51G, which is fundamental duties and directive principles of state policy, under that compensation was awarded. And again, I feel this is also another case where sufficient compensation was not awarded, because if I remember correctly, each industry had to pay merely 10,000 rupees worth of compensation for doing damage that is irrevocable. In fact, Mr. MC Mehta was awarded 50,000 rupees for costs because of his tireless work in this matter, but each industry only had to pay 10,000. So this was of course 20-30 years ago, but in my mind that's not nearly enough. But the crucial part is there were not, as Aayush had mentioned, the pollution control boards as per the Water Act, the Air Act. These were not established. So right. Compensation had to be provided by the provisions of the Constitution. And all of these things, the current socio-political context, the jurisprudence sort of pointed towards the need for a specialized body to deal with these kinds of things. Because as you've seen, the orders that were passed they were good. They were very, in spirit, they were amazing, but right. They were lacking a sort of scientific rigor. Like, why as a tannery, which is polluted irrevocably a river, only have to pay 10,000? There was no scientific justification for it. 10,000 is a round number, so it was imposed, but that doesn't make jurisprudential sense. So all of these things gave a need was felt for a specialized body with an expert in it, so to speak. And these three cases particular, the 87 one is the oleum gas leak, Indian Council for Environmental Legal Action, and AP Pollution Control Board really pushed the Supreme Court felt a lack of expert member. They wanted to have some sort of expert body which is able to scientifically assess the situation, in addition to obviously having a legal judicial control over disputes as well. So both these things, the need for an expert and the need for governing, judicially governing environmental disputes, these two things led to the development of the NGT. However, it was still not as we see it today. Because what happened first was two acts were passed. Firstly, the Environmental Tribunal Act in 1995, but it was never sort of implemented. It was just a paper tiger. And then the Environmental Appellate Authority Act, the NEAA. As you can see, the Advocate Shivani Ghosh's comments on it, why it didn't work. But let me just explain the outlook, the scope of functioning for the NEA. Now, if you look at the NGT's jurisdiction currently, it can be divided into three heads. I'll get to them in detail, but out of these three heads, only one head in a limited way was within the purview of the NEAA, which is to say that environmental clearances which were granted as per the 94 EIA Act, those could be challenged before the NEAA. So that was it. That was a very, very limited scope. You couldn't just bring general environmental disputes. You couldn't bring general appeals against a particular decision taken by a pollution control board or any authority under the NGT Act. It was a very specific limitation, and this led to, there were key vacancies. It has a very limited mandate, as Advocate Shivani Ghosh has mentioned, and it essentially was not able to do much. It was, in fact, my bosses currently, Advocate Ritik Datta and Rahul Chaudhary, they started their work at the NEAA, and they had to face such continuing defeat, and many cases they had gone against them, but that was just the nature of the authority, and it wasn't really what you would call a friend of the environment, so to speak. And this is, of course, let me just preface this by saying these are all my personal views, and do not in any way speak to what my organization believes in and what their values are. Everything said in this discussion is my personal opinion. So the NEAA was functioning in a sort of lackluster way, in a haphazard way. And that again led to the formation of the NGT. As you can see, many years later, so for many years, there was a very, you had to go to sort of the higher courts, the constitutional courts, to seek any sort of relief. And that led to the formation of the NGT in 2010. There was also this Law Commission report in 2003, which again pointed to the need for scientific expertise in adjudication of environmental disputes. And so you can see that this factor was a really key element in the establishment of the NEAA. One of the main reasons, and the NGT, one of the main reasons the NEAA failed, however, was because there was too much judicial, administrative and executive control over appointments in the NEAA. So it could not sort of be independent in its functioning. And, this is something that we then saw later after the 2017 amendments to the tribunal's rules done by the current government, that this has also now become a problem in the NGT, where the independence is slightly at risk because the appointment method has changed. I'll get to that in a minute. So how NGT works? So there are three types of jurisdiction that the NGT exercises, as I mentioned earlier: Section 14, Section 15, and Section 16. Section 14 relates to, as you can see, any environmental dispute arising under Schedule 1 Acts. What are Schedule 1 Acts? There are about 7-8 acts, including Water Pollution, Air Pollution Act, Water Prevention and Control of Pollution Act, Air Prevention and Control of Pollution Act, Environmental Protection Act, Biological Diversity Act, Public Liability Insurance Act, so on and so forth. Are all these acts included in Schedule 1? And if there is a violation of any of these acts, then under 14, you can go and approach the court. Then we have 16. Now, 16 is a very important. So 14 is a general sort of act. A general sort of provision, because it lays down any dispute. So it has a very wide variety, a wide range, a wide scope, but it's limited to Schedule 1. So it has to be an act, a violation of an existing act, some provision of an act. Then we have Section 16. Now, Section 16 is much larger insofar as, sorry, not much larger, but rather much more specific in its outlook, because it deals with appeals. Now, appeals against what? Appeals against decisions passed by authorities. All of these authorities that Aayush mentioned, all those boards, all those committees, all of so on and so forth. So if there is an environmental clearance which is granted and you want to challenge that, then you go under Section 16. If a pollution control board, which does sometimes exercise a quasi-judicial role, might I just add, in cases of some pollution control boards are designed to have an appellate authority within them. So these, if you have some kind of, say, for example, you want to challenge a consent to establish or consent to operate. Some state legislatures are designed in such a way that the first appellate authority is an appellate authority established by the Pollution Control Board itself. So, for example, in Goa, if I want to challenge a consent to operate for a company that is established, right? It could be, say, a fertilizer company. They have the Pollution Control Board has offered them granted them a consent to operate, and I want to challenge that because it's not been granted properly. Then I have to first go before the Pollution Control Board appellate authority itself, and if that an order is passed there and I'm aggrieved by that, then I can go to the NGT. So this is section 16 has that way a specific role, but there are many other specific headings which come under it. And you know, if anyone in the audience would like, they can peruse section 16. You'll see about, I think, 8 or 9 different categories. So a pollution control board orders, or forest clearances, or environmental clearances, or CRZ clearances. These are all permissions that are granted. So any permission you want to challenge, any consent you want to challenge, then you go under section 16. And then section 15. Now, section 15 is perhaps the widest scope of the 3 jurisdictions, because it is there's this case which I would like to discuss, monthly tax zone. It is an appeal filed against NGT order regarding the construction done on the Rajakalways in Bangalore, which are the lakes basically. So in this, the Supreme Court held that section 15 is just a wide island. You know, the Supreme Court, the NGT can order a lot of relief, compensation, restitution just because of this section 15. It is different from section 14 because it's not limited to Schedule 1. So for example, mining, the laws related to mining do not come under Schedule 1. You know, be it the concessionaire rules, be it the Minor Minerals Act, none of these come under this. But if there is damage from mining and you want some restitution, for example, then you can approach the court under section 15. And because they have such wide powers for restitution, for compensation, the court can accordingly even function without section 14. So this is a sort of a loophole in the law, because while section 14 and even Schedule 1 has been created to limit the scope of NGT to those acts only, section 15 allows a loophole because it allows you to compensate for any damage that's caused to the environment because of an act which is outside Schedule 1 as well. So it's very legal. This monthly tax zone case is a piece of quite ingenious jurisprudence, because the court on interpretation of the provisions have expanded to such an extent to really give meaning to section 15. You know, it's not it sort of empowers the court, and I found that a pretty interesting example of judicial intervention to ameliorate the powers. Right. Now, suo moto. These were the 3 headings under which a person may approach the NGT. There is also suo moto jurisdiction. Now, as you might see on the screen, suo moto jurisdiction has been a bit of a contentious issue, because the Act doesn't provide for any suo moto jurisdiction, but the NGT has repeatedly taken suo moto cognizance of various issues. There are some that I have highlighted. There are others also that they have, read an article in, say, the Hindustan Times, if I remember correctly. There was one by Vishwa Mohan, which was then converted into the National Clean Air Plan. There was an application that the NGT only converted based on this one article by Vishwa Mohan. Then we had one by, I think, in an article in the Hindu, which was then converted to a suo moto application on river stretches. You know, all the polluted river stretches in the country. I think there were around 351. All of them were covered by one suo moto application of the court. So the court has also sort of done its interesting maneuvering. And now, as perhaps Aayush can fill you in on this better, is the Supreme Court has recently passed an order allowing for suo moto jurisdiction. So there was an application filed before the court determining whether the NGT has valid suo moto powers or not. And in fact, suo moto powers have been accorded. And Aayush has been working on that matter or a related matter. So I'm sure he can fill you in on that better. Ayush, do you want to
Not
take a
on
minute?
that matter, but a similar issue.
Yeah.
So this is the Ankita Sinha case where the judgment came out, I think 2 days ago, where the Supreme Court allowed suo moto powers to a tribunal, the National Green Tribunal. And this is the first time the Supreme Court has done this with respect to any other tribunal, because they have held that the function of this tribunal is of tremendous public necessity and public good. And the tribunal cannot shut its eye to environmental degradation or environmental pollution if it can see it merely because an applicant has not approached it for that reason. Of course, there's going to have numerous ramifications and jurisprudence going forward. But yeah, this is the Ankita Sinha case, and this is the reasoning that was given by the Supreme Court in this issue.
So yeah, as you can see that the NGT has particularly been given a special role amongst other tribunals, and I feel that's undoubtedly necessary. I might be slightly biased because I exclusively practice.
The rescue, right?
Sorry?
This the Supreme Court has again come to the rescue, because I mean, I remember having this discussion. We also shared a link of that article on our study circle group, and as I also discussing with Aayush, okay, considering it's a tribunal and probably no other tribunal will have suo moto powers.
Yeah.
But considering the fact that it's an environmental issue and a public issue at large, probably this is how the Supreme Court might have.
Yeah.
That does have suo moto powers. So,
Maitreya, you might be a little conscious of the fact that if the NGT takes suo moto cognizance of all matters, you won't be required, buddy. Neither would I.
I'm sure life would still get taken on board as an amicus, because that level of expertise is there, and I'm sure Ritvik sir or Rahul sir would give me something to draft. But no, just more on that later. So suo moto jurisdiction, as has been pointed out, has been accorded to the NGT, which I think is definitely something, a step in the right direction. And let's see, yeah, as Ayush pointed, bound to lead to some very interesting conclusions. I hope it doesn't lead to us losing our jobs, Ayush, but let's see how that goes. Locus standi. Now, as some of you might know, locus standi is basically on what grounds are you approaching the court? Do you have any sort of authority? Do you have any sort of locus to stand before the court and make your submissions? And as some of you might know, that perhaps in commercial cases or in criminal cases, there has to be some reason why you specifically are coming to court. Not anyone can take up a matter. If there's a commercial dispute between X and Y, then I cannot randomly just go and be like, I'm going to file a case against Y. There has to be some reason why I am going. So as Ayush hinted at this earlier, the provision of locus standi has been ameliorated, it's been expanded, and SaveMon was one of the first cases. I think in 2011, the order was passed. So just 1 year after the establishment of the NGT, 1 or 2 years. In this case dealt with the Tehri Dam, the hydroelectric part in the north that was being constructed, and the villagers were sort of the applicants there. And a lot of contentions were made that these particular villagers do not come within the concept of aggrieved person, because they're far from the project, so on and so forth. They're not exactly, personally interested in the project. But the court completely negated such contentions, and you can see the order that was passed. I think it's a tremendous case. In fact, it is our bosses, Advocate Ritik Datta and Advocate Rahul Chaudhary, who are dealing with this case as well. So Amit Maru is again a very interesting case, because as you saw, section 16 was appeals to clearances and permissions, but section 14 also, who can approach under section 14 has also been given a much wider scope under Amit Maru. I think these have essentially allowed a relaxation in the approach, because now, and one thing that I must say slightly candidly is that a lot of the clients who come and a lot of people who are fighting the good fight in the environment often have to face external pressures. They often are sometimes harassed, they're bullied, and sometimes much worse, actions are taken by big industrialists, by mining companies, by the government. So if there was sort of a strict limitation on who can approach the courts, then it would be very easy to target those people. It would be very easy to make them the victims of some sort of harassment and to shut the case off. But because it's been given such a wide scope, because who can approach has been ameliorated to such an extent, that that danger has sort of been mitigated to some extent. Of course, it still happens. Several of it has happened. I have personally experienced that as well. But I think this is again another important judicial intervention where the scope of who can approach the NGT has been widened, and aggrieved the person who the term aggrieved person has been given a really wide amplitude. So essentially, like in public interest litigations, I mean, this was one of the unique legal innovations that Justice Bhagwati and Justice Krishna here brought about, was to expand the scope of who can come to the court. So NGT also similarly has done that. Now you might have a question: what kinds of cases are coming before the court? So a study was done analyzing all the cases from 2011 to 2016, all the judgments that were pronounced. And there was a gradual increase in the number. So in 2011, around only 28 orders were passed. In 2015, I think it reached the highest in, I think around 880 odd judgments were passed. In 2016, 510. And what were these kinds? So the the most type of cases, or rather the segment with the highest number, is industry operations. So these would be your typical clearances, your consent to operates that are challenged, your consent to establish, any kind of pollution activity being caused, either water, air, soil, by industry operations. When nature is again a very generic phrase to use, but it essentially encompasses, forest case, forest diversions, or hi. You guys want to say hi to my cat? Hi.
Oh,
She's also pretty interested in having the discussion right now. But anyway, so nature includes, forest case diversions, wetland protections, such kinds of things. Now, mining, as you can see, is the biggest contributor. And if you look at it, industry will include all kinds of industry, nature will include all kinds of cases within it, but mining has very specific limited scope. It's just about mining and the pollution caused by mining. So if you just look at this, it becomes evident that by itself, mining is perhaps, and this is mining for usually energy purposes, it's also mining for other purposes, but predominantly there is a lot of mining taking place for energy generation, thermal power plants. So by itself, mining and energy generation are probably the most environmentally polluting industry that exists today in this country. We do very well on many indicators. Like if we look at our cumulative, the country's per capita greenhouse gas emissions, we are half of the global average. So we do excellent there. But our mining and our energy generation is just terribly bad. I mean, it's very polluting, and it often targets communities which are very, very marginalized, very disenfranchised, and not much is said on this issue. So this is something that I feel is pretty important, and the audience should definitely note that, if we have to target key industries going forward, not in terms of like a aggressive targeting where we just want to shut them down for the sake of it. Like, of course, this conversation would not be possible without energy and without electricity, which is definitely more likely than not to have come from coal if we're sitting in India. But at the same time, if you want to create some sort of changes given the current context, then these are the industries that
bringing in sustainable development is
absolutely. Like, firstly, let's try and understand what sustainable development is. Also, let's have a proper conversation, because right now, as we see in the court, they keep reiterating that there has to be a balance between ecology and economy, and as I already pointed out, that's not sustainable at all, and that's maybe not even development. So these are sort of the cases, an overview. And the last point, you might find it interesting that majority of cases, the Ministry of Environment, which is the nodal agency, apex authority, they are the respondents. So there has been a failure on the administrative side, completely to protect and safeguard the environment. So that is why, as you might, or the audience might know, that the biggest litigant in this country is the government, and there's a reason for that. Appointment of judges. Now, this is a very crucial part, because appointment, of course, is what determines the existence, the functioning of the court, and how it functions. We saw several, like as I had already pointed out, cases that ameliorate the scope of the NGT, and this was only because the NGT had tremendous judges. They had judges who would take it upon themselves to do justice, even if the advocates were not able to do it, even if the case was not sufficiently developed, they would take it upon themselves that we have to see that justice is done. Particularly, I would like to mention Justice Swatantra Kumar, who was just one of the most phenomenal judges that independent India has seen, in my considered opinion, because the way he dealt with environmental law cases. I mean, he's known as the Green Judge of India, right? There's a reason for that. It's because he took it upon himself to do justice. And one of these initially, that's how the NGT was. If you analyze the orders passed, in the first 5 years, there are so many which have just completely shaken up the entire ethos of the country, because you were not expecting the judiciary to be so proactive. You were not expecting them to take such a interested place, and that was, I think, in my opinion, that was because a certain independence of the judiciary had been maintained. That is now at stake. Now, as you can see in this order, the appointment process was talked about, and they said that how there has to be some sort of independence. Again, in this matter, also the court reiterated that Braj Foundation versus Government of UP. But after the 2017 amendment to tribunal rules, what has essentially happened is there has been a crippling of the independence of the judiciary. And now the judicial members are outnumbered by the members appointed by the central government. So essentially what that means is the central government decides who comes and who doesn't come. And as I've just pointed out, when the highest litigant, or the litigant with the most cases, is the government itself, then you can understand who or what kind of individuals they would be keen on appointing. I'll just leave it at that. I'm sure the audience can make of it what they will, but you have to see that the insidious sort of crippling of the judiciary or independence of judiciary that took place. So right now we are at a little tricky stage in the NGT, because there are numerous vacancies. This is of course a reality for tribunals across the country, not just the NGT, where the number of there is just a huge vacancies in all the appointments. And again, the audience can make of that what they will. The mandate of the NGT. Now, how does once you have gone to the court, once they have admitted your matter based on jurisdiction, whatever, how do they pass the orders? Sustainable development, as I've already told you, is something that has been interpreted in numerous ways, and you can't really say what sustainable development completely means. Precautionary principle, again, that's you have to the sort of implementation of that has not been clear cut. But the polluter pays principle is something which you can say is definitive. This you pollute and therefore you have to pay. It's definitive in its outlook. Whereas the precautionary and sustainable are sort of fluid. But I feel that there have been some distinct problems with the polluter pays principle also, which I'll just highlight. So understanding these are the three main problems, right? There has been a lack of certainty as in what kind of pollution would entail what kind of compensation. There has been no uniformity in calculation, despite there being experts. I alluded to this earlier, that experts were meant as a sort of remedy to unscientific orders. But as we see, that exactly is my considered opinion, has not been solved. And one more thing that we have to realize is that any kind of compensation that is paid by the government is essentially borne by the tax-paying citizen. So how much of that really is the polluter who's paying, is something that we have to sort of take note of. Why do I say there's a lack of certainty of nature? Because as you can see, these 4-5 cases that I've put, now polluter pays principle has been used to recover property and house tax. It's been used to recover environmental compensation charge paid by vehicles. It has been used to for costs of remediation. It has been used in various other things. And now, as we can see, things like property and house tax or compensation charge for vehicles, these are traversing the boundary between executive action and judicial action. They, in a way, they're creating some sort of like it's an executive action to create a tax. It's a legislative action, but they have used the polluter pays principle to do that as well. So it's an evolving concept, and it's not entirely certain what polluter pays would encapsulate. Are these compensation charges that were charged in Manoj Mishra invalid? Do they not come within the polluter pays principle? Is something that there is still no clarity on. Of course, these orders have not been overruled, so there's no reason to assume that they are invalid. But my point is that there is still a sort of opacity in what comes under the ambit of polluter pays. Right. This is something that I feel particularly strongly about. There is no uniform calculation for how much money has to be paid. In Forward Foundation, it was that 10% of the project, of the total cost of the project would have to be paid. But why 10%? Who decided that 10% is how much a polluting industry should pay is not really determined by anyone. And this sort of had particular problems in this, the Volkswagen case, as some of you might remember. The Volkswagen case was when Volkswagen was putting faulty pollution reading devices, the amount of pollution that is generated. They had completely manipulated the test results. And the amount that they were penalized with for doing this, like, I don't know the scale at which they would have caused environmental pollution, because they completely cheated and they were completely fraudulent. The penalty was only 100 crores. Now you might think 100 crores is a lot, but I mean, this company has a sort of is valued at more than $75 billion. To just put that in perspective, that is 0.017. 100 crores is 0.017% of USD 75 billion. So that is how much they had to pay. So it's far from the 10% of the project cost. It's 0.017% of the cost of the valuation of the whole company. And there's no reason for why 100 crores was put out. They've just said 100 crores. It's a big number. It's a round number. It reminds us of those 10,000 that were rewarded in Vellore. But again, there's no reason for why. Like, how did they come up with? Just sounds nice. 100 crores ostensibly seems so, but we don't know. So these are slight problems in the understanding of polluter pays. I'd also just briefly like to mention a study that was done by Kiran Pandey and Susan Chacko. They analyzed polluter pays principle orders from April 2019 to April 2018 to April 2019. And what they found was, out of the 50 orders that were passed, 42% were between the range of 1 lakh to 3 crore, whereas 15%, 30% were between the range of 5 to 75 crores. So you can see a wide range from 1 lakh to 75 crores has been imposed. And there is no sort of uniform left to the discretion of the judges. It's not that often they give scientific reasoning for this. And I feel that it goes against the very reason for having an expert tribunal if you're just going to pass unscientific orders. In fact, there are two cases: Krishnakant Singh versus Triveni Engineering and DSM Sugar versus Shailesh Singh. And the tribunal has actually mentioned dependence on quote unquote guesswork for arriving at the amount. They've actually mentioned that this. So, make of that what you will, right? I feel that it's something that we could perhaps do better on.
So, Maitreya, just a small question that, what do you think the solution is for this? I mean, when it comes to computation of damages or calculation.
So, there currently exists a lot of sort of studies or research undertaken by the CPCB in evaluating how much compensation should be. Now, this is typically limited to industrial pollution that is being caused. There is a CPCB report on the in-house assessment of environmental pollution caused by industries, and they lay down the compensation. They have a formula, and they lay down the specific reasons for having those criteria, and they lay down if you for the different categories of polluting industries. So government operated, individual operated, accidental damage, all of these, the formula are given. But this is limited to one specific part. If we could have the CPCB, the Apex Pollution Control Board Authority, creating these kinds of guidelines, it's something that can definitely help and assist, because even there have been various cases filed where the CPCB has been directed to sort of formulate guidelines, to come up with guidelines where they don't exist. In fact, that work is being done by my organization, by our organization as well, where you sort of ask the CPCB that please, there is a lapse, there is a lacune, there is a gap existing, so please fill that gap. So I feel that that's something along those lines could be done. Or at least even the court can take it upon themselves. They can form a committee, they can create these kinds of reports. So there are a lot of things that can be done. I feel that it should be a little clearer. So these sort of problems emerge when ordering compensation. You don't know how much to ask for compensation.
So at least some sense of uniformity is probably
required. Absolutely, some sense of uniformity and some reasoning for uniformity. Why? I feel like if it's 100 crores, it should be justified that why it's 100 crores. If it's less, then sure. If you can logically say that less has to be paid, then less. But I feel that if for such a wide-scale violation, there has to be much more compensation. Like otherwise, it's just some sort of what's it called, symbolic order that's being passed. But anyway, now how has the Supreme Court dealt with the NGT? That's been particularly interesting. H.R. Dattu's order is, of course, right there for everyone to see. He said that we're not going to interfere because they're doing something good for the people. I found that pretty interesting, as opposed to other courts who are not doing good for the people. But anyway, that is Justice Dattu's observation. They have, of course, upheld various NGT orders. I'm not going to deny that the Supreme Court has intervened where it has to, or rather when it was the cases were brought before them. They have definitely, it's not like they have negated the NGT or treated it like second guess their decisions. They have quite often done that. Increasingly, however, we see I have my reservations on how the current trends of the judiciary are. I think the independence of the Supreme Court is something that is becoming an issue that is becoming talked about more and is in the public sphere more, because we see an assault on the judiciary. And I am not going to deny that or hide from that. In fact, I would like it to be discussed more. So, as the NGT is often steps in the way of development projects or economic growth, you see the Supreme Court not so willing to agree with them more and more. In fact, not a lot of big orders were being upheld, or they're not decided on quickly. You see a lot of a lot of symbolism from the court, where they will be very eager to uphold like the firecracker ban order that was passed. That's such a ridiculous small issue but they will be very eager to uphold this order that we are doing some firecrackers during Diwali is going to be prevented, and that's how we solve air pollution. I have my reservations on that. I think very limited. Even if you prevent all firecrackers from burning, doesn't mean you shouldn't. Of course, firecrackers are useless. But I mean, let's not satisfy ourselves that work is being done because firecrackers were banned. I think that's it's a little silly. But anyway, so Supreme Court has sort of had this, and there are increasingly more and more challenges. These, I feel, are the three main challenges faced by any person going to the NGT and existing NGT as it is. Now, the applicants often have a huge problem with technical expertise. So if I want to challenge the environmental clearance granted to a big hydropower project, I have to go through hundreds and thousands of pages of scientific analysis, quote unquote scientific analysis, right? EIA reports, environmental impact assessment reports are put out. And it's the duty of any interested individual, if they want to challenge it, they have to find scientific problems with that, with the assessment. And I think that's a serious challenge to a lot of people. Like if you want to challenge a irrigation project that's coming up in your area and you are just a small farmer, your land is going to get because they're going to be drawing canals through your land, it's going to get completely damaged and destroyed. And now you want to challenge this, but if you are unable to understand the intricacies of how a perfect irrigation project should look like, then you cannot compare that to a badly produced EIA report. You don't know what is right, what is wrong. You just see numbers. How are you supposed to know what should be there, what shouldn't be there, how much should what be, what are the levels of pollutants, this, that? I mean, these are incredibly technical, nuanced issues. And, there often is a sort of gap between an interested party trying to bring justice and utilizing the scientific information, which is again goes back to why it's so important to have an expert tribunal in these kinds of matters, because these are very highly technical information. I mean, if you want to challenge say for instance, an iron smelter, or a LNG vaporizer, or or a copper refinery, these are all very, very, there are a lot of technical aspects involved in it.
Right.
And you cannot simply just go and be like, these guys are going to cause pollution, inko band karwao, because that won't fly. You have to point the scientific, the fallacies, the misrepresentation, and for that you have to understand the science. So it's very difficult. As a lawyer, and I'm sure Aayush also, we have had to learn these sorts of things going forward. You have to understand how this science works, how what a windrose diagram is, or what ground level concentrations are. As a law student, you have no idea about these things, but it's very interesting because you have to understand that, because otherwise you can't
Probably
challenge
the BSc degree after the LLB is
yes, sir, I'm thinking PhD. Doctor advocate. No, I'm just just joking. Then, of course, the problems with access to information is a huge part that plagues any country. IPI Act is also being diluted. So these are really, very fundamental key issues which plague any applicant. Appointments, as I've already mentioned, is under threat of lack of independence, and compensation is something that is one of the main remedies that can be granted by the court, by the NGT, is compensation, either for restitution, a remediation, or because there has been violation done and these people, the victims, deserve some sort of compensation. It's one of the strongest, one of the most important weapons that the NGT has. But there, as I've already mentioned, that there are certain fundamental problems in calculation of this, which really, I mean, if you can't calculate how much compensation you're paying, then that's like you're on a, very shaky foundation, because it can be subject to challenge, it can go to the higher court and they can be like, there's no scientific reason for why so much is imposed, and that gets caught in litigation, and the victims basically end up not getting what they deserve. And, as you know, justice delayed is justice denied. I strongly believe that. And so these are some problems I've identified in my practice with the NGT. And I feel that if these can be targeted, then, we really have, NGT has passed some incredible orders, and just to sort of, I won't get into what has been done already. That's free for everyone to see. But there have been numerous orders where large-scale projects have been stopped because of the NGT intervention, and so much has been done for people on the ground. But I feel if these problems are addressed, then we can do it. These are my references. If someone would like to have a few.
Yeah, so when we do put up the PPT on our website, like there's a study circle page, so we'll incorporate all. I mean, maybe you can share this. We'll incorporate it into our PPT.
Sure, I would love to. I would love to. So if you found value of it, then I would definitely.
Yeah, definitely. Yeah. So, and I think even Aayush is going to share a write-up of sorts. So we'll merge the two and just put it up on our website. So quickly, before we conclude, how, from an NGT perspective, how practically has your experience been, like in Pune and in Kolkata?
I'm not sure. What do you mean by?
So, I mean, you've been practicing before the NGT, right? So, in terms of practice, in terms of orders and all, you've had a good experience.
Right. I think it's so. There are some
It's
particular.
your personal viewpoint, but I just thought, as someone,
No,
because we don't
definitely.
have any lawyers who are exclusively, in this field.
Yeah. So I feel it's amazing in some ways because the whole rigor of procedural law in lower courts is just mind-numbing.
Right.
I mean, you want to file a case in the civil court, even something as a summary proceeding, which are very short in nature, not very complex. Those also take you. It's just very difficult to go about doing that. You have to have someone you know who knows how to operate and maneuver the system. On the NGT, filing of a case is one of the simplest things. It's unbelievably good, to be very honest. If you compare that to different district courts, session courts, judicial magistrate courts, those are absolute headaches. Like procedural law is definitely one of the biggest drawbacks in this country. Right. And I think NGT completely does away with that. After the pandemic, in fact, it's become completely virtual. So it's been, appearing before the court is so much easier because it's done over, like conference or WebEx conferences. So it really helps that. And we've seen a very expeditious disposal. That is also true. You compare to the lengthy timelines that are there in district civil courts and, even the Supreme Court, High Court, sometimes those cases go on for generations, and that's not an overstatement. So in that way, the NGT is very, very expeditious, and it has really facilitated filing, which I think is a huge, huge problem in different courts. So in that way, it's been completely very pleasant experience. The judges have also been really keen to listen to us. So I have no complaints from the existing administration.
I have worked in multiple tribunals, not just the Green Tribunal. I have worked before the Securities Appellate Tribunal, Company Law Tribunal. When it was the Company Law Board, I've worked before them there, the Debts Recovery Tribunal. So after having worked with all of those as well, I still feel that the Green Tribunal has a very streamlined system.
Right.
And most importantly, what I feel is that this is one of those few tribunals where the expert member, their viewpoint and the viewpoint particularly is really given a lot of consideration to. I've worked before the Securities Appellate Tribunal and the National Company Law Tribunal, where often the expert members tend to follow whatever the judicial members are saying. But again, I do not have a lot of experience with the Green Tribunal either. But whatever little experience I do have, I do see that the judicial members do pay a lot of attention to what the expert members have to say, what their opinions are. Because like Maitreya pointed out, it is a very technical subject. It is a very technical tribunal in that sense. You need a lot of scientific expertise and a person who understands that scientific expertise. Besides that, like most tribunals, this tribunal is also divided of basic procedure. It works on the principles of natural justice, which is that there should be no bias. People shouldn't be condemned unheard. Basic principles of natural justice, just like most other tribunals that are there. Most of them are not bogged down with procedure so much. I am seeing a tendency though, that often like recently, in a few orders and judgments that I've come across, I have seen a tendency that there is a view where often applications, etc., are dismissed on technicalities, which I think was never the intent of the act. And I do not think that is how the tribunal should proceed in any event.
So, before we wrap up, just one last question to both of you, that, in terms of lawyers or the citizenry, what would your expectations be from them when it comes to, probably from an enforcement perspective or even an awareness perspective? Even if a person lawyer is not exclusively or even appearing or practicing in the NGT, would lawyers are there any steps that any lawyer or any citizen may also take? in terms of, just raising their own awareness maybe, or
Sure.
some sort of enforcement done?
As I said, I'm
Mhm.
somebody who's new to the field in a
Right.
sense. So I probably can give at least one perspective from that sense,
Mhm.
which is mostly it's about being aware. The
Mhm.
more aware you are, because again, as Maitreya pointed out, suddenly in today's day and age, the conversation around environment has gained a lot of socio-political impetus, so to speak.
Right.
There is a lot of discussion on issues like climate change, on environment, and there are a lot of studies that are being conducted to understand these issues. There are a lot of researches that are being conducted to understand these issues. As any lawyer will tell you, that the most important aspect of law is constantly staying abreast of new developments, whether it's new case law, whether it's new policies that are being made out, whether it's news reports. These are all things that every lawyer and every citizen also, in my opinion, should in general keep abreast of. And I think that translates the same into this, that these are issues that you need to care about, you should care about, and just keep an eye out, read, listen. Study circles like yours certainly help, where you call advocates like us to have a discussion on issues of environmental law, on practice before the National Green Tribunal, what it entails. I think sessions like these, putting them up on social media, these also serve the purpose of enhancing the number one, the expertise of people, the understanding of the law, and second, just the awareness that yes, these are subjects that are there which are generally lost. I'll also bring up another aspect, which is a very personal aspect to me, which is when most people get into the field of law. When you're joining law college, you have at least some aspirations that I'll go to the court and I'll do something good. I will have some view which will be put out in court. It will change the country maybe someday. But as time passes, most people either move into commercial or corporate, which I did as well, where you move into commercial corporate law, where most of the time you are either sitting and drafting agreements, you're sitting and drafting, and nothing wrong with that, because that's also an equal part of society. But somewhere, at least one portion of your time, one portion of your life, you should spend some time in maybe picking up a pro bono case, maybe assisting somebody on a case where you care about the issue involved. So that's at least my opinion. Maitreya?
Yeah, I mean, I definitely can't deny with everything you said. I would just like to add one small thing, as citizens, not just lawyers, we are constantly voting, we're either voting with our wallet or we're voting with our ballot. And I feel that on both these issues, we have to proceed with some amount of circumspection. We have to be cognizant of who are we paying and who are we electing. Until these two issues, until we're not sort of paying companies that are doing good, and we stop paying companies that are polluting, and until we stop electing people who do not care about climate and not willing to make it a central agenda to politics, until then there's not going to be much change. Once we create a societal change, I think the NGT is a reflection of that in many ways. And in fact, even any branch of the judiciary is a reflection of public sentiment, which is why we saw in the 80s, as I mentioned earlier, that whole expansionist ideology. So I think as ordinary citizens, definitely we have to vote better. We have to act better. And as lawyers, as Aayush pointed out, if there are any other lawyers in this gathering, we have to pick up more cases. There are plethora of cases, and it could just be as simple as implementation of an act. The Biodiversity Act has so many committees and this and that boards that are established. How many of them are in existence today? Wetland rules are notified. How many state governments have actually declared the wetlands within their state and come out with a natural list? There are n number of acts that you can pick up and just go and ask for implementation of them. And I think if these are not very technical or very difficult things, because all you're saying is that do your job as per the law. So if there are lawyers in this forum who would, definitely pick up these kinds of cases, I think it's bound to help.
Yeah. So thank you, Maitreya. Thank you, Aayush. I think we'll do our bit, like study circle will do its bit by at least, sharing this video on social media. And, I think it would go a long way. So the whole purpose behind this was also that, generally what we do is we have different topics, like maybe arbitration, more on the commercial side, where the idea is to reach out to younger lawyers and they should at least have an idea. So purpose behind this session was that, it's important to have awareness about environmental laws as well. Considering that in civil society now there are discussions around climate change and, environmental destruction happening. This is how we can contribute in terms of the legal aspect of it. So that was also the reason why, we thought it was an important topic to be taken up. That it's important that even as lawyers, we should be aware of, like from a legal perspective, how could we assist you all or work on this aspect. So with that, thank you, Aayush. Thank you, Maitreya. I would just request colleague Shruti to just give a conclusion.
Thank you, Kunal sir. Thank you, Advocate Aayush Singhvi and Advocate Maitreya Ghorpade for joining this session. And yes, I'm sure that it was a very informative and brief sessions on environmental law, as Advocate Singhvi has already told us about various environmental laws, like he started with the genesis of the environmental law and various acts, Wildlife Protection Act and Water Prevention and Control Act and Air Pollution Act and all those acts. And obviously, Advocate Ghorpade has already spoken about NGT and its procedures and various case laws, which helped us, to get into the zone of the environmental law, and we really got to know more about like what exactly happens in NGT tribunals, like how who can approach to NGT tribunals. So it was very informative session, and thank you so much for coming in a study circle session.
Thank you for hosting us.
Thank you, ma'am.
So nice having you both, and hopefully let's see if we can have some sort. I mean, it's been an interesting topic. Let's see if we can have another session, like a dialogue based or a panel based discussion, where we can, like I said, only 91% has been covered, so maybe
Absolutely. I think one of the major discussions that everybody should be having is what is sustainable development, and someday maybe we'll have a conversation around that. Sure. Just that small part.
Yeah.
Right. Everybody, thank you. Have a good day.
Yes. Thank you.
Thank you so much.
Thanks, Aayush. Thanks, Maitreya.
Bye-bye.
Bye-bye.